Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will talk about another judicial pronouncement by the Honorable Supreme Court of India, wherein the scope of Section 438 of the Code of Criminal Procedure 1973 that provides for grant of anticipatory bail was discussed. The name of the case is Nathu Singh vs. State of Uttar Pradesh 2021 SCC Online SC 402. Now, without going into the specific facts of the case, the crux of the matter is that the High Court of Judicature at Allahabad passed an order wherein it was breathing hot and cold at the same time. While the same order, on the one hand, it rejected the application for anticipatory bail under Section 438 of CRPC, and on the other hand, it directed the applicant to, I quote, appear and surrender before the court below within 90 days from today and apply for bail. Their prayer for bail shall be considered and decided as per the settled law. Till then, no coercive action shall be taken against the applicants. The court ends. This order, passed by the High Court, was challenged before the Supreme Court on the ground that once the final relief of pre-arrest was declined to the applicants, there is no protection available to the applicants under Section 438 of CRPC, and hence the High Court could not have contemplated grant of any such protection. Thus, the moot question to be answered by the Supreme Court in this case was whether the High Court, while dismissing the anticipatory bail applications of the respondents, could have granted them protection from arrest. This was the question that was framed by the Supreme Court. Now, let us discuss the remarks of the court in relation to the extent of power exercisable by the courts under Section 438 of CRPC. The Honorable Supreme Court firstly discussed the case of Sushila Agrawal vs. State NCT of Delhi 2020 5 SCC 1, wherein following propositions were laid down. A. Grant of anticipatory bail under Section 438 of CRPC is ordinarily not limited to a fixed time period and should inure in favor of the accused till the conclusion of the trial. B. Normal conditions under Section 437 subsection 3 read with Section 438 subsection 2 should be imposed while granting anticipatory bail, and if there are specific facts and circumstances, it is open for the courts to impose any appropriate condition or introduce any peculiar features in the order depending upon the necessity. Now, before adverting any further, let us briefly understand Section 438 of CRPC and what it talks about. Section 438 talks about direction for grant of bail to person apprehending arrest. Section 438 subsection 1 states that where any person has reason to believe that he may be arrested, then he may apply to the High Court or the Court of Sessions for a direction under this section that in the event of such arrest he shall be released on bail. The court may take into consideration various factors in this regard, and depending on these factors it may either grant the bail or reject the bail or pass any interim order. In this regard, the proviso to Section 438 subsection 1 is relevant. The proviso states that in case of rejection of anticipatory bail or in case no interim order has been passed by the High Court or the Court of Sessions, it shall be open for the police to arrest the applicant. Section 438 subsection 2 states that the High Court or the Court of Session, while granting anticipatory bail, may include certain conditions. Thereafter, the court came to the question relating to what happens when an application under Section 438 is rejected. According to the court, when an application under Section 438 of CRPC is rejected, it is open to the police to arrest the applicant, and the proviso to Section 438 subsection 1 of CRPC does not create any restrictions on the same. Rather, it is merely clarificatory in nature that unless an individual has obtained some protection from the court, the police may arrest him. The Honorable Court also observed that grant or rejection of an application under Section 438 has a direct bearing on the fundamental right to life and liberty of an individual under Article 21 of the Constitution of India, and therefore the provision, I quote, needs to be read liberally, and considering its beneficial nature, the courts must not read in limitations or restrictions that the legislature have not explicitly provided for. Any ambiguity in the language must be resolved in favor of the applicant seeking relief, the court ends. Coming to the question relating to the provision of law under which the court may issue relief to an applicant after dismissing their anticipatory bail application, the court observed that such a power does exist under Section 482 of CRPC that recognizes the High Court's inherent power to pass orders to secure the ends of justice. This provision reflects the reality that no law or rule can possibly account for the complexities of life and the infinite range of circumstances that may arise in the future. Thus, in order to cover such contingencies, the legislature has enacted Section 482 of CRPC. It was further opined by the court that it cannot remain oblivious to the peculiar situations that may arise, and I quote, there may be circumstances where the High Court is of the opinion that it is necessary to protect the person apprehending arrest for some time due to exceptional circumstances until they surrender before the trial court. Court ends. In such cases, even if a case for anticipatory bail is not made out, then also the court has powers to pass appropriate orders. Similar powers are also vested with the Supreme Court of India under Article 142 of the Constitution of India. Thereafter, the court passed a word of caution that, I quote, such discretionary power cannot be exercised in an untrammeled manner. The court ends. It was also stated that the court must necessarily narrowly tailor the order to protect the interests of the applicant while taking into consideration the concerns of the prosecution, and such an order must be a reasoned one. Based on all this reasoning, the court finally held that the order passed by the High Court of Judicature at Allahabad, wherein it rejected the application under Section 438 of CRPC but granted protection from arrest to the applicant without assigning any reasons for the same, fails to withstand the legal scrutiny for want of reasons and non-consideration of the concerns of the prosecution or the investigating agency. Further, it was also held by the Supreme Court that the period of 90 days granted to the applicant cannot be considered to be a reasonable one in the facts of the case. Hence, the order passed by the High Court was set aside to the extent of granting protection for 90 days to the accused persons. So what are my concluding remarks? I feel that this case emphasizes the importance of Section 482 of CRPC. Even in the earlier post, we had discussed that in relation to orders framing charges or refusing to discharge, the court has the power to look into the same both under Section 397 and Section 482 of CRPC. Thus, where no power could be traced in relation to an exercise of power, then such power could always be traced under Section 482 of CRPC, provided that the exercise of power is in a just and reasonable manner. Through this case, the Supreme Court also made clear that even if an application for anticipatory bail is rejected, then also the High Courts are not precluded from granting tailored protection to accused persons. The life and liberty of a person has been put at a higher pedestal by the Supreme Court than the rights of the prosecution to investigate into the matter. According to the court, there must be a semblance of balance between the two while passing of any such order. There are countless situations where the accused persons may take benefit of this order by the Supreme Court. For example, if a person is apprehending arrest but is about to get married, then he can approach the courts, and even if his case does not fall within the strict contours of Section 438 of CRPC, then also the court may grant him interim protection till the time he gets married. Or if there is a death in the family of a person apprehending arrest, then also the benefit of the culmination of the interpretative process that has transpired in this case could be taken by such person. Life is complex and so are its needs. I agree with the underlying reasoning of the court that there cannot be a straitjacket formula, and when the statute itself confers inherent powers on the High Court, then the same must be exercised beneficially in favor of the individuals. However, an inane approach bereft of reasoning must be avoided. So I hope you enjoyed listening to this show. Please do not forget to like and subscribe us. See you next time. Till then, stay tuned.